This is Legal Matters. Hi, I'm Debbie Moraes. This program has been designed to address the critical, contentious, sometimes contentious issues that affect consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. We want to begin once again by thanking our legal counsel and sponsors of this program from Bazar, Grasso law firm in East Providence, Jackie Grasso and David Bazar.
Okay.
Welcome. So again, today we'd like to speak about family law, more about family law. In recent segments, we've addressed the execution of wills, trusts, power of attorney, healthcare directives, but we've only briefly touched on the idea of legal guardianship or conservatorship, those who essentially oversee your personal and financial protection when you're not considered able to protect yourself. And what exactly does that mean? What criteria, beyond the fact that you might have an underage child, what classifies you as being unable? Some people are caught in the crossfire of domestic disputes or are disabled or are incapacitated as adults or seniors. If you need a legal guardian or you might be appointed as one, stay tuned. There are things here that you might need to know, the duties, the limitations, and even some of the practical inherent difficulties associated with it. So there's much to cover. Let's begin with some basic definitions and understandings of guardian ad litem, and conservatorship. What are they and what are some of the differences? Jackie, do you want to start?
Guardian ad litem is simply an individual appointed by the family court and sometimes superior court who would represent the interest of a child, a minor child, where custody or visitation is at issue. So it must be a contested issue. Oftentimes they're either lawyers or could be, in Massachusetts, they tend to appoint psychologists, psychiatrists, sometimes social workers, depending on how serious the situation is. So that person is an extension of the judge's arm, is what I like to say. So the guardian ad litem basically can go out and speak to anybody associated with the child, whether it be the parents, the grandparents, teachers, doctors, even clergymen, counselors. That person has to report to the court as to what he or she believes is in the best interest of the child, rather than dragging a child into court, which is not something that's favored by judges. Then they have a guardian ad litem go out and do that. Now they also use GALs for elderly people who cannot take care of themselves either, so they would have somebody representing the interests of the elderly person, not necessarily a guardian, but a guardian ad litem.
And a conservator, a conservatorship, what does that entail and what might the differences be between the two?
Trying to run with that?
I'll run with it. Conservatorship is often like a guardian, but it's an individual who's appointed to oversee a person's financial affairs. And it would be a probate court appointment in Rhode Island, usually an elderly person. Doesn't even have to be an elderly. It's somebody who's not competent to handle his or her financial affairs. If somebody is under the age of 18, it can either be in probate court or in family court in Rhode Island. In both cases, in probate and family court in Massachusetts, so they combine both courts.
And so, just to run back quickly to the guardian ad litem we were talking about, generally that's a court case where someone has been appointed to represent the interest of someone who's otherwise unable to represent themselves. A child, for instance, doesn't have legal capacity to represent themselves in a family court matter or in a superior court matter for that, in that instance. And it runs with the case, and when the case is over, generally that guardianship is over.
And can the same person be both the guardian and conservator? Is there any reason that a judge couldn't choose one person to be both?
I don't see why they couldn't. Yeah, I don't see why they couldn't.
And in probate court, oftentimes they'll do that, and they'll say that I'm appointing you as the guardian over the person and estate or property of the ward, which is a conservatorship, the person who is conserving the property of the ward.
And apart from, as we spoke of earlier, someone who's under 18, how does a judge decide who needs to have a guardian or a conservator appointed, and how does he get to know who's among the lucky candidates?
What I do is I'll ask the court to appoint a guardian ad litem. The minute I know that there's a custody issue, rather than spending hundreds of thousands of dollars often at times, you want to nip the problem in the bud. I'll ask the court to appoint a guardian ad litem. Sometimes the judge can do it on his own, But it's always someone who's on a list of approved GALs. So I just can't go into family court and say, pick me as a GAL, because I'm not trained as a GAL. So you have to have special training to do it, and you have to be on a list. And judges pick from the list, or lawyers can often choose between themselves, as long as it is somebody that is approved by the court.
And in Superior Court, a guardian ad litem is appointed when there's a child whose settlement needs to be approved by the court. And again, there's generally a number of people who do those types of cases, and their obligation runs through the end of the case and is over, as opposed to who gets to be picked to be a guardian over a person making the rest of their life choices, who they're going to live with, where they're going to live, or the conservatorship, who's going to take care of that person's finances for the rest of their life, which is in Rhode Island generally through probate court. And there the judge will look for, well, who's the most likely person to fill that role? Is it a child? Is it a brother, a sister, a parent? It depends on the situation.
And if someone is appointed a legal guardian, it's likely to be not someone who's on the judge's list, but rather perhaps someone who might be closer to the family.
Correct.
Or might know someone, or have some intimate connection with the child. And how do they go about vetting who is most appropriate, or is it just that someone might step up to the plate and say, I volunteer to take care of this child, if we're sticking with the underage child for the moment?
Well, sometimes people will fight over who's going to be the guardian of the child. We're not talking about GALs anymore, but suppose a parent wants to be a guardian of a grandchild because the parents of the child are not, I'll give you a good example. Mother and father are both in the military, and they get called overseas. So the grandparents often step in and are able to make decisions on behalf of the children. And in that case, the best way to achieve that would be by a guardianship. It doesn't have to be permanent, it can be temporary. They don't like to continue temporary guardianships for too long. However, but getting a guardianship over grandchildren in that situation would enable the grandparents to speak with physicians, to enroll them in schools. Most school systems want a legal guardianship to enroll children in schools. I've had that happen.
In Rhode Island, if it's all agreed upon by the family members, you can do that in probate court. If it's a child and there's a contest, then there's a Supreme Court case that says those cases should be heard in family court, because the family court has more expertise in deciding what's in the child's best interest and who should be the guardian over the child.
And oftentimes what happens in a litigated case in family court is the parent of the child is contesting the guardianship. So where a grandparent, have a case like that right now, where I have actually an aunt who took over guardianship of a nephew. And in this case, the mother of the child was not able to care for it, and the biological father contested it, even though he never was adjudicated the biological father. And also the biological mother contested it. And it took some time and a little bit of litigation. We were able to appoint my client as permanent guardian over this child.
And it's interesting because we run into these things a lot, especially in family court with the guardianship over a minor child, where perhaps the mother has died, the father has been out of the picture forever, maybe is hundreds of thousands of dollars in arrears in child support, now all of a sudden wants to step back in. Well, there's a couple of issues there. Number one, is that in the child's best interest to be with a person that they have not had any contact with in a long time, say 10 years even? And number two, who's going to be responsible for collecting that back due child support, and who does it get paid to? Because it was payable for the child's benefit.
And in that case, does the child ever get a vote? I don't mean if the child is 2 and unable to speak his or her mind, but if you have an 8 or a 10-year-old child who maybe might want to get to know who that father is, doesn't necessarily mean he has to be the legal guardian or whatever. So does the child get to speak with the judge in private chambers and have that fleshed out a little bit more deeply before the judge proclaims or decrees whoever's going to have the last word here?
Well, again, it's unusual that a child be interviewed by a judge in chambers. They call it an in-camera conference. Over the course of my career, I think I've had 2 occasions where there was an in-camera conference. The child was 10 in one case and probably 7 in another. Judges do not like children in court. They don't. So if the child does get a vote, or we want to know what the child is thinking, that's appropriate to have a guardian ad litem appointed on behalf of that child.
Okay, and if we don't speak now just about children, but perhaps where the stickier wicket comes in, what about adults who need to have a guardian? How is it determined? Apparently there's cause for much alarm, especially in Florida these days, not just adults but seniors. How do they get to determine who is truly unable to take care of their own affairs?
So in Rhode Island, there's a document that needs to be filled out before a guardian is even appointed, and that's called a DMAT, or Decision-Making Assessment Tool. And a doctor fills it out. And the doctor goes through what are all of the things that this person can do and cannot do, really the activities of daily life, so to speak. And if the doctor's assessment is that this person maybe can't make decisions regarding money or where to live or medical decisions, then the court at that point in time will say, well, someone has to be appointed to make those decisions for that person.
At what point does a lawyer get called in? At the point where perhaps someone is starting to make some wrong decisions or incapable of taking care of himself? Does the court then ask a lawyer to take care of this person, find a guardian? How does that process play out? What is your role in this? Or what might it be?
In probate court in Rhode Island, if it's an elderly person, it doesn't even have to be an adult who's in that situation, the court automatically appoints a guardian ad litem just for a limited purpose to go out and interview, they call it the individual, the ward, to see what the limitations are. And that guardian ad litem, again, can also speak with doctors and family members and counselors, clergymen, if necessary. And that guardian ad litem is responsible for providing a report to the court within a short period of time. Sometimes it's an emergency, they'll have to go out right away and get an emergency guardian appointment while the guardian ad litem is still doing his or her job.
So there's an investigative role,
yes,
perhaps?
Yeah.
And where would a lawyer come? I can imagine that if someone has a guardian and there's some issue with it, might they be calling you in to help determine whether or not there even is? Maybe the ward, him or herself, might need a lawyer. I don't really think I need a guardian, thank you very much. How would that play out? Would they contact you? How could they if they aren't responsible for their affairs? How might that play out on the ward side of it?
Well, if the ward is competent enough to contact an
Yes.
attorney to fight a guardianship, then you
Yes.
can be pretty sure that they're probably
get
going to succeed in fighting that.
And apparently in Florida, that's a very big issue and becoming a source of litigation and some, I guess, laws that are being proposed where maybe a child decides, I think I want to be the guardian of my aging parent, and for perhaps not necessarily reasons of complete integrity. Then the ward says, I think I want a lawyer, I want this overturned, and that guardian who has ill intent can call in 3 doctors, a shrink who's on her payroll or his payroll, another doctor and another person, 3 people who can speak and vouch for her to say, I really need to be a guardian of my mother or my father or whatever, and these things are being litigated because there's a source of great controversy and trouble.
Yeah, I think that if you have a situation where someone is competent enough to make those calls and make those kinds of decisions, that probate, in Rhode Island, probate courts are in each of the cities and towns, that the probate judge of that city or town where this case is being litigated is going to look at that person, assess the person, him or herself, and determine that a guardianship is not necessary in this particular case.
Most of the times when we're dealing with a guardian, we are contacted by family members. So if truly it's somebody who cannot speak on his or herself, it's someone from the family that does that. I had an incident where an individual had a massive heart attack and survived, couldn't communicate, could barely take care of himself. And in that situation, we petitioned the probate court in Providence, and they had both his parents appointed as guardians. And he was in his 30s, I believe. But just because there's a guardianship, people should understand it can be terminated at any time. So another family member can come in and petition the court to terminate the guardianship. Or let's say the situation I was talking about where the ward had a miraculous recovery, and he can petition the court on his behalf and say, I don't need this anymore, I want to terminate the guardianship.
So I actually have a case where a young adult, in his 20s, maybe early 30s, was in a very bad car accident and suffered some traumatic brain injury. The mother stepped right up and became his guardian, has been his guardian for a number of years, but he actually is recovering. And she came in and said the other day that, I've been talking with my son, and we think maybe through the next year or so, if he keeps going on the path he's going on, we might be able to ask the court to end the guardianship, because he seems to be getting to a point where he can make good decisions and take care of himself.
So as a lawyer, would you do anything or nothing right now, or you just wait till she comes back to you and says, okay, it's time, then you'd go to the court?
Right. In most guardianships, you have an annual report you have to file. So as that annual report comes due, it's also an accounting of this is what came in, this is what's been spent on his behalf. When you file that report and the annual report as to how the ward is doing physically, it might be the time to say, well, let's also file a motion to terminate the guardianship, because when we bring him in and let him talk to the judge and say, you know what, he's done pretty well, he's ready to take over.
Well, I want to ask you a little bit more about how the actual termination process takes place. But back just a moment ago, you were speaking about the courts and how someone might be voting to take care of him or herself. Suppose the ward is able to say, I really don't want this medication or that treatment. Comment, what happens if the court just simply disagrees with what this ward, this patient, doesn't want to do? Does that then give the court reason to say, clearly, that's not a reasonable decision, you need a guardian? I don't know, maybe it's they don't want any more life support or other very aggressive measures, and a judge might not think that that's in an individual's best interest, but if they're sound mind, can the judge override that? Do they override that?
The court's not just going to step in a situation without somebody bringing the case to the court.
Granted.
So first there has to be somebody else who disagrees with that person's decision, a parent who disagrees with an adult child's decision, or an adult child who disagrees with a parent's decision.
And if that's the case, what would happen? How would that play out?
Well, then the judge has to assess the situation like any other guardianship, and not only is it a question of whether or not the decision they agree with or don't agree with, because oftentimes that's irrelevant. It's whether or not the person's competent to make the decision.
Okay. And if someone has been ill, has had a guardianship, now is in the hospital, suppose it isn't a child, could it be a nursing home, or could it be a hospital who also could petition for there to be a guardian? Maybe the nursing home doesn't think that the adult children of that person should be the guardian. How might that play out?
In nursing home, they would contact the Department of Elderly Affairs, and they would have, sometimes they have CASA volunteers that go out and make assessments and act as an advocate on behalf of the person in the nursing home. So sometimes that it can happen, yes.
Yeah, that's actually a fairly common event, is that some outside agency, a nursing home, a hospital, somebody where there's not a family member who's there immediately to jump in and take some responsibility. As Jackie says, they might contact the Department of Elderly Affairs. There's a list of volunteer guardians and that type of thing, and people get involved in whatever need to be taken care of on that.
And if someone is right now of sound mind and says, I think in the near future I might need a guardian, might they come to a lawyer? How would that process play out? Would you help them with input as to why they think that they might need a guardian, who that should be? How might that play out?
Well, that's part of an estate plan. I mean, the quickest and easiest way to avoid all that is to have a durable power of attorney in place for finances and a durable power of attorney in place for health care decisions. Because if somebody is incompetent, that's when that power of attorney takes effect, and at that point the person is already legal standing to act on behalf of the individual. So you have a document that says, this is who I choose to act on my behalf in the event that I cannot.
Our job is to avoid the guardianship.
Because it's
Guardianships are expensive.
Are they?
There's a lot of bureaucracy that goes into what happens many times and who's going to get appointed, and maybe it's somebody that you don't want appointed as your guardian who gets appointed. Our job is to say, if a guardianship ever became necessary, who would you want to be your guardian? And as Jackie said, well, now let's create a document that avoids the guardianship.
So it's a good bridge for some of the practical problems associated with the whole idea of it. For example, an adult parent, a parent has a son and a daughter. Both would like to have that guardianship. Daughter says, oh, the brother has done some wrong. I don't know, maybe not a convicted felon, but just done some wrong. In that case, then you end up with a battle. Does she end up having the reason to accumulate documents that attest to why her brother is not fit and should not be considered? Is that a war? Is that a legal issue? Is that a mediated event? Excuse me?
Well, you can mediate if they both have to be willing to participate. And that's interesting that you bring that up, because Roger Williams Law School has a program that offers mediation services not just in family court but in all other areas, and I see it happen in probate court a lot. But in a situation where a brother and sister are fighting over a guardianship, you can bet that one is going to have a lot of information about the other as to why somebody is not appropriate to be a guardian, and that would probably be, presented before the court.
Is it admissible as evidence if...
Depends on what it is.
Yeah, it depends what the
If
evidence
it's
is.
hearsay, no.
Okay. Other than hearsay, okay.
I have mediated probate matters. In fact, I think that mediating of probate cases is much more akin to family court than mediating superior court cases, because it's not usually, or oftentimes not really about money, or it can be if it's an estate you're probating or mediating, but oftentimes it's about family dynamics. And so the mediation that goes into that is very similar to what goes into a family court case.
Okay. And suppose someone is being considered to be a guardian. What would you advise, or what kinds of questions should that person be asking themselves, or perhaps you, before they sign on and have to take responsibility? Who makes a good one? Who qualifies? Do you have to be eligible? You don't get a college degree for it. What things should someone know?
Well, you'd have to have capacity, so it means you have to be over 18. More importantly, the individual has to agree to it. So if the individual doesn't agree to it, then that's not someone you want as a guardian. The individual has to be responsible financially. They have to understand what their limitations are. And when you become a guardian, it's just like having a durable power of attorney. That guardian can handle all of your finances, take your checkbook, write checks on your behalf. So that the guardian has a financial and a fiduciary responsibility to preserve and conserve the estate of the ward. So it doesn't mean they can take a trip to Foxwoods or Tahiti with that money. And unfortunately, it does happen, and that becomes a source of litigation at times.
Is there a list of what the limitations of a guardian or conservatorship? Is there a rules book of where the ceiling or where the parameters are for what someone can and can't do as a guardian?
I don't have a list, but what I do is provide a form letter to my clients, just like I would if somebody's appointing an executor, an administrator in a will, in a probate case. I would send a letter and I would tell them, these are your responsibilities. And just so that I cover myself and know that I've made this conveyance to the client, so that the client is fully aware of what their responsibilities are, and what their limitations are.
And really what you're looking for is somebody who is going to make good decisions for the ward. So someone who would be a good parent, even if it's the child taking care of the parent in a reverse situation. You want them to be able to make decisions about where they're going to live, who they're going to associate with, what kind of activities they're going to be able to participate in, just like you would with your child, and what to do about managing their money so that there's money to take care of them, and that it's protected and safeguarded.
And speaking about children, or a child in particular, a recent case that you had to address, it was in the news not that long ago, where there was a boy who was killed. And there was a discussion and a debate, actually, between someone who was a guardian and a mother who had just been imprisoned for having shot the father of this child. Who gets to decide about the burial? Do you want to flesh out those details and the controversy?
Yeah, it was a very tragic situation where young man, wrong place, wrong time, was shot and killed. What compounded that tragedy was his mother was in jail for killing his father. So typically when a child dies, the parents would make the funeral arrangements and there wouldn't really be much of a controversy. But in this situation, since the mother was in jail and the father had been killed, there was a guardian appointed for him, an aunt, and she had done a great job of taking care of this child through his lifetime. And when the time came that he died and the funeral arrangements had to be made, the guardian made those arrangements. So the argument on the other side and the funeral home's concern was, does the guardian have legal authority to make funeral arrangements for a ward who's died? And part of the question is, does the guardianship terminate on the death of the ward? And there's case law on both sides of that issue. Although this woman was appointed guardian through the family court, and the family court decree said that she was the guardian until further order of the court. So my argument from that perspective would have been, well, court hasn't terminated her guardianship yet. My real argument, though, in that case was, as the guardian, there was nobody else who had legal capacity to make a decision for that child and for his funeral arrangements, because the mom's in jail, and my argument is she lacks legal capacity to do anything because she's incarcerated. She can't enter into a contract. She can't make arrangements with the funeral home. In fact, the guardian paid the funeral arrangements for that child. So we had that issue. Then the funeral home compounded that with a statute, which I call a safe harbor for them, which simply stated is, there's a pecking order listed as to who can make funeral arrangements. The guardian's on there, so obviously a guardian can make decisions for a ward even after the ward has died, but it started with the parents above her. The problem is, my argument is, that that safe harbor for the funeral home isn't the law as to who can do it if the case is brought to court, which it was in this instance.
It wasn't?
It was brought to court.
It was.
And the Superior Court, in its equitable jurisdiction, had the legal authority to decide who would make the decision. And there's case law on that in Rhode Island that said, in fact, in that case, it gave a pecking order, but it said the court has to look at the circumstances of the case. And in this instance, it was my argument that where the mom is jailed for killing the father, who would have been the one who could have made the decision if he had been alive, shouldn't be rewarded for the fact that he couldn't make the decision and be allowed to make the decision. The only natural person who would have authority to make it under those circumstances, make that decision, was the guardian.
And it had nothing to do with what the individual choices were. Mom, as I understand, voted for cremation. Aunt supposedly had said the family would like this child to be buried near the father, which is what the whole of the family wanted to have happen. And I think I remember reading somewhere in your remarks, correct me if I'm wrong, that while this might have been litigated, and yes, as you said, it was, if the child had been cremated, there was no reversing that, whereas if the child had been buried and they had later decided that it was okay to cremate it because that's what Mom said, that could have been, could have taken place too.
I kind of argued that the Superior Court would have made an irreversible error if they cremated him, because the mom was still in jail. And and actually in this case what ended up happening is I sort of mediated by discussing the case with the mom, and we came up to an agreement. But if the judge had to hear the case and make a decision where it's going to allow the child to be cremated, my argument was, well, that can't be reversed on appeal to the Supreme Court, or when the mom got out of jail, if it was to be litigated further, as opposed to bury him with his father and let's see where the thing goes from there.
Wow, quite a case. And of course there are many more like this, and even for adult incapacitated seniors. We hope that this has been helpful to you. We thank Jackie Grasso and David Bazar. Our discussion of legal matters will continue, and we hope that you found this helpful and insightful. Stay tuned. Our discussion will continue.